So we're looking back into the Interpretations Act of Canada, Article 8.1. It says duality of legal traditions and application of provincial law, both the common law and the civil law, are equally authoritative and recognized sources of the law of property and civil rights in Canada. So we see that there are two different dualities of legal tradition, right? We see that there are two operations of law within the provincial law and within the federal law. There is common law that is in operation, and there is civil law. Now, Canada is not denying the fact that there is common law in operation here. The Ontario Provincial Offences Act, and this enactment operates in each province. Each province has its independent Provincial Offences Act. Now, it states common law defenses. Every rule and principle of the common law that renders any circumstance a justification or excuse for an act or a defense to a charge continues in force and applies in respect of offenses. So here we see that the common law is authoritative, and every rule and principle of that common law is still in operation for us to stand under. Looking into M.A. versus Ryan, Supreme Court of Canada made it clear that the law must develop in accordance with the Charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom. So common law is authoritative in Canada, and every rule and principle of the common law is still in operation, and it still acts as a justification or an excuse or a defense to a charge that is applied against you. Meads versus Meads, a claim that the relationship between an individual and the state is always one of contract is clearly incorrect. Now notice that the judge used the word individual. He didn't say person. He said individual because he knows what he's about to say here. But the state has the right to engage in unilateral action subject to the charter. All right, so there are some people out there, right, that will claim that the charter is useless to you, and the charter means nothing to you, and the charter only applies to the government. And if you want to exercise your common law rights, well, use the Bible or use some other mechanism. Or they'll make up some funky operations of law and they'll tell you this is the way to do it. This is how to exercise your common law rights. But they won't claim the charter and they won't claim to international law. But they make up a straw man and they'll champion their system and they'll champion their teaching. And they'll tell you, well, if you listen to me, well, the government will never be able to do nothing to you, and they won't apply the law to you. But the courts have already said Canada will unilaterally apply their laws against you, only subject to the charter. So if your defense is not built upon the charter, then they will apply their laws against you. R versus Hines, 1999. Prior to the charter's advent, the individual. Now notice again, the subject or the player. It's not person, right? It's the individual. And if you understand the terminology or the designation individual, it opens it up for both capacities, either in a civil context or in a fundamental right context. The individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative, and we should add here, judicial arm of the state. So prior to the charter's advent, where common law now exists, where common law is now expressed, where fundamental rights, natural rights, human rights are protected within the charter, we as individuals, we had no means of protecting against the incursions of the state. They limited and abridged our individual rights. Respect for the rule of law hinges the existence of public order, mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. So prior to the charter, right, law operated here in Canada that it was for the better of public order, and that compliance was mandated, and that directives and ordinances, we had to obey them, even if they limited and abridged our natural right. A primary purpose of the charter was to change this relationship of the individual with the state and its laws by endowing individuals, by giving individuals with an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. Well, let's correct that judge a little bit. Let's tighten this up a little bit. And let's correct this judge's misconception of the law. Because we know that the Supreme Court of Canada has already ruled that it does not take a court order. A court order is only one means, one way, one avenue to protect your fundamental human right. It does not take a court order to enforce your fundamental right. R versus Wagner, the rule of law. The rule of law not only finds itself in the preamble to the Charter of Rights, its spirit is manifested throughout the document. The idea that there are certain fundamental, unwritten principles that govern all members of society, including legislators, and which judges are expected to enforce, is not particularly new. So Wagner just told us, right? And the courts just declared, right? Concerning the rule of law. Well, let's look at that rule a little closer. In Thomson Newspaper Limited versus Canada, while individuals, notice again the subject and player, individuals, as a rule, have full legal capacity by the operation of law alone. What's that trying to say? You have full legal capacity. You have natural rights. You have fundamental rights. You have human rights by operation of law alone. Artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights, his common law rights, his human rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long before the organization of the state. Now, this is the rule of law. This is the rule of law. That you have full legal capacity by the operation of natural law alone, and that you may stand upon your constitutional rights. You may stand upon your common law, your human rights, because it is a rule of law. R versus Wagner. The contemporary concept of unwritten constitutional principles can be seen as a modern reincarnation of the ancient doctrines of natural law. So what are they saying to you? What are they trying to tell you? Well, the Constitution, right? The Charter that brings forth common law. It's actually bringing forth the reincarnation of the ancient doctrines, the ancient truth, the ancient teaching of natural law. The Chief Justice goes on to note that these rules bind the legislative, executive, and judicial branches. The debate is not so much about whether such norms exist, but what those norms are in relation to any given case, where a litigant calls on such norms to help him or to aid him in what he is facing. The rich intellectual tradition of natural law seeks to give the law minimum moral content. It rests on the proposition that there is a distinction between rules, civil law, and the rule of law. Rules and rule systems can be good, but they can also be evil. So natural law, human right, is showing us that there is a distinction between these operations of law, that you can stand as a statutory creature under civil rights and civil law, or you can stand as an individual man or woman under your human rights, under natural law, under common law. Finally, at the developing fringes of the new natural law, which goes by the name of human rights, those unwritten principles tend to be largely replicated in the text of the Constitution, with Section 7 of Canada's Charter of Rights striking me as a prime example. The judge here didn't say that it was a primary example. He said it was a prime example, meaning a good example, meaning a thorough example. So he's telling you, right, that Section 7 of the Charter of Rights and Freedoms, that article of law that is enumerated in the Charter, is bringing forth natural law, is bringing forth common law, is bringing forth human rights, and only a man or woman can invoke those rights. That's why we find Graham writing in the Canadian Charter of Rights Decisions Digest from Justice Canada. He states, read as a whole, it appears that Section 7 of the Charter was intended to confer protection on a singularly human level. Well, but I'm not a human. I'm not a human being. I'm a man. I'm a woman. Well, you're deceived again, because it means the exact same thing in foundational law. If you say you're a human being, you're declaring you're a man or you're a woman. That's what you're declaring. And if you confuse yourself, well, your fault. A plain common sense reading of the phrase everyone has the right to life, liberty, and security of the person serves to underline the human element involved. Only men and women, only human beings can enjoy these rights. Everyone then must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities, statutory creatures incapable of enjoying these rights, and include only human beings, only men and women. Well, why would they say that? What led them to say that? Because the courts have already ruled, right, that Article 7 is an expression of natural rights and natural law and human rights and common law rights. And the only individual that can declare or call on these rights are human beings, men and women. And that's why Graham is telling us here, if you operate as a statutory creature, Section 7 is no good to you, cannot help you. Remember, right? We just read that prior to the Charter's advent, an individual had no effective means to protect upon an incursion of his natural rights, of his fundamental rights. But since the advent of the Charter, now we have a means. And the judge says you can get a court order against that. But I said to you, that doesn't only take a court order. That's not the only remedy that is in the law. That's not the only remedy or measure that is out there in the Canadian law. And here we see it in Canada versus Sam Levy and Associate. First, and most importantly, the Constitution is, under Section 52 of the Constitution Act, the supreme law of Canada. And any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force or effect. All right, I might sound a little hard here, but I'm not trying to be mean. And I'm not trying to come against anyone looking for their rights and looking to exercise their human rights. But do you see what the judge is saying? To the extent of the inconsistency. And most individuals have no idea how to express the inconsistency. They don't know how to take the statutory law and show the court or show those in position of authority where the limitation and abridgment comes from. That's why in many of my videos, right, I've already shared these operations of law. I've already showed you in the enactments where they've limited and abridged our human rights, such as incorporating us into their corporate body and making us an officer of their corporate body. Inconsistent with the Charter, inconsistent with Section 7 and Section 26 of the Charter. The invalidity of a legislative provision inconsistent with the Charter does not arise from the fact of its being declared unconstitutional by a court, but from operation of Section 52 alone. Thus, in principle, in theory, such a provision is invalid from the moment it is enacted. And a judicial declaration, a judgment from the court to this effect, is but one remedy amongst others to protect those whom it adversely affects. So a judgment from the court going to court is one remedy amongst others. So there are other remedies to protect you against those inconsistent enactments, against those provisions of those enactments that are inconsistent with the Charter, that are inconsistent with your human rights. And operating as your agent without your consent, without your permission, and taking absolute title from you and returning to you a qualified title is a limitation and abridgment of your fundamental right to property. And the enactment reads as follows in Article 46: the registered owner of land with a qualified title may apply to the land registrar, not to the municipality, but to the land registrar, to be registered as the owner of the land with absolute title. So there's a measure, there's a remedy already within the statutory power. Well, I would take my properly built claim of recognition down to the registrar's office, and I would tell him that I would like to apply for absolute title on my land. And I would like to include my claim of recognition so you know who's making this demand. I agree with her that the rule of law, not rules of law, but the rule of law, foundational law, human rights, common law, is quite apart from the terms of any written constitution, part of the constitutional DNA of this country, and that its precepts must be abided by and must be applied by judges, no matter how strong may be the prevailing winds or how challenging the social or political environment in which an issue arises. So talking about the rule of law, talking about full legal capacity, talking about common law rights, talking about human rights, the courts have said these precepts, this foundational law must be abided by, and the judges are under obligation to apply these operations of law in our favor. And it doesn't matter how much opposition the Crown brings to a court. The judges are to rule based upon foundational law, based upon human rights. Peel Regional Police Services, Chief of Police. The courts too must conform. They must conform to the rule of law. The rule of law is the very foundation of the Charter. And it stands to reason then that the courts are duty bound to apply the Charter. So where are your common law rights? You talk about common law rights, right? Where are they? Well, they're in the Charter, right? And what must the court do? Well, they must abide by these common law rights. And these rights are to be applied on your behalf by the judges, no matter how much the Crown wants to kick against it. That's the rule of law. That's foundational law. That operates against legislative, executive, and the judiciary. All of them are subject to the rule of law. The Emergencies Act of Canada. And whereas the Governor and Council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental common law, human rights, that are not to be limited or abridged even in a national emergency. So the rule of law says that you and I have natural rights. You and I have common law rights. You and I have human rights that are never to be limited or abridged. That's why Thompson Newspaper Limited versus Canada says, while individuals as a rule of law or have full legal capacity by operation of law alone, by the rule of law alone, we have full legal capacity. And under that full legal capacity, we have rights that are not to be limited or abridged ever. And those rights are protected within the Charter. Statutory creatures, they enjoy civil rights and powers only upon the approval of statutory authorities. That's not the rule of law. That's rules of law. The individual may stand upon his constitutional rights, common law rights, his human rights, and he owes no duty to the state. Well, where did these rights come from? Did they come from the International Covenant on Civil and Political Rights? Yes, they do. Because it puts an obligation upon Canada to respect your human rights. But originally, before the International Covenants, these rights existed by the law of the land, long before USA or Canada or Germany or the UK or Britain ever became a state, ever became a country. The International Covenant on Civil and Political Rights and the other international human rights instruments, they bring forth our common law rights. They bring forth our natural rights. They bring forth our human rights. They did not create them. DeVito versus Canada. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents, which Canada has ratified. So the Charter should bring forth your rights. The Charter should bring forth your human rights, your common law rights. Nemeth versus Canada. It is presumed. Listen to what the court is saying. It is presumed that the legislator acts in compliance with Canada's obligation as a signatory of international treaties. The judges presume that the enactments do not limit and abridge your human rights. That's why the courts have said it is important to note that the onus, the responsibility, is on the one bringing the challenge to demonstrate not only the restriction of the right, but also that the state has not abided by the principles of fundamental justice. They haven't respected the rule of law. They've limited and abridged the rule of law. by forcing me to operate as a statutory creature, by taking absolute title away from me, by limiting and abridging my human rights, my rights that existed long before the creation of the state, my rights that exist within international law, my rights that exist within the Charter. Vincent versus Ottawa. Section 11.2 of the Courts of Justice Act reads as follows: the Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by courts of common law and equity. So the Superior Court of Justice has the authority, has the power, and has the jurisdiction to rule over common law, to rule over your human right. Now, to get a court to do that, you have to access the original jurisdiction of the court. You can't go into a statutory court and hope to have your common law rights respected. But that's a video for another day. But for those who say the courts don't have the power, oh yes, they do. They have the power. And the courts have already said they have to apply these rights. They have to apply this remedy on your behalf when you bring it to the court. But remember, to exercise your rights, it doesn't necessarily take a court judgment. And Zinger versus the Queen says it is a recognized principle of international law that a state may not invoke the provisions of statutory law, the provisions of their enactments, as a justification for its failure to perform its international obligations. So they can't point to the enactment and say, well, look, we were allowed to operate. The enactment gave us the power to operate as their agent. And therefore, we operated as their agent and we took absolute title and returned to them qualified title. Well, by doing that, right, you failed to perform your international obligation. Well, what's the international obligation? I'm allowed to hold my property alone, not in association with anybody else. And that is one of the rights that can never be limited or abridged, because it's a natural right, transferred into a human right, expressed in the covenant, and no limitation and no abridgment can be placed upon that right. But yet you took absolute title from me, and you returned qualified title to me.